My landlord illegally kept my security deposit and threatened me with eviction. So I studied tenant law for 6 months and took him to court. I want to be upfront that I am not a lawyer. I am an accountant by profession, which means I am most comfortable when things balance, when records are clean, and when procedures are followed correctly. I did not go looking for a fight. The fight came to me, and when it did, I handled it the only way I know how, methodically, thoroughly, and with extensive documentation. I rented an apartment for 3 years. My landlord, a private property owner I will call Gerald, owned several units in the area and had a reputation, which I learned only after moving in, for being difficult about security deposits. I did not know this when I signed my lease. I found out the way most tenants find out, by experience. When I moved in, I did everything correctly. I conducted a thorough walkthrough, documented every existing imperfection in writing, and took time-stamped photographs of every room before I moved a single item in. I kept copies of everything. This is my professional habit. I have done it every time I have rented anywhere, and it costs nothing except time. I was a model tenant for 3 years. I paid rent on time every month by bank transfer, creating a clean paper trail. I reported maintenance issues in writing. I followed every provision of the lease to the letter. When I gave my 60-day notice, I hired a professional cleaning company and kept the receipt. The move-out walkthrough was where things turned hostile. Gerald arrived with a pre-printed list of charges that, I realized quickly, he had prepared before setting foot in the apartment. Over 40 minutes he went through every room and identified damages. Every single one was either a pre-existing condition documented in my move-in photographs, normal wear and tear explicitly excluded from tenant liability under state law, or in one case, a repair he had committed to in writing 18 months earlier and never completed. I said very little during the walkthrough. I took photographs of everything he pointed to. 2 weeks later, his letter arrived. He was returning approximately 38% of my deposit. The itemized deductions included a carpet stain that was visible in my move-in photographs, paint wear near the front door that any reasonable reading of state law classifies as normal wear and tear, a cleaning fee despite my professional cleaning receipt, an administrative processing fee that does not exist as an allowable deduction under state law, and the towel bar that he himself had agreed in writing to replace. The total he was keeping was significant. I read through the deductions twice. Then I opened my laptop and looked up the relevant statutes. It took me about 3 hours to confirm what I had suspected. Gerald was in violation of my state's landlord-tenant law in at least 4 distinct ways. The carpet deduction contradicted my documented move-in condition. The paint wear deduction was impermissible under the statutory definition of normal wear and tear. The cleaning fee was not supported by a professional receipt as the law requires, and the administrative processing fee had no lawful basis I could find anywhere in the statute. I sent Gerald a formal demand letter citing every applicable statute and giving him 14 days to return the balance plus statutory interest. The letter was polite, specific, and left no ambiguity about what I was asking for or why. His response told me everything I needed to know. He was dismissive and slightly condescending. He told me his deductions were entirely proper, that I was welcome to pursue the matter in small claims court if I felt differently, and that in his experience tenants who made these kinds of demands rarely followed through. That last part was clearly intended as a discouragement. It had the opposite effect. I filed in small claims court. The filing fee was $40. In the process of preparing my case, I discovered additional violations I had not originally planned to raise. Gerald had failed to provide the written notice about security deposit handling that state law requires within a specific timeframe after move-in. He had also failed to hold the deposit in a separate account as required. Both failures carried their own statutory damages independent of the deposit dispute itself. I also filed a complaint with the State Tenant Protection Agency, and a separate complaint with the City Housing Authority regarding insufficient notice he had provided for apartment showings during my final months. These complaints cost nothing and created an official record. Gerald showed up to the small claims hearing with an attorney. I arrived with a 3-ring binder. Inside, my original lease, all move-in documentation with timestamped photographs, 3 years of written communication, my professional cleaning receipt, the written agreement about the towel bar, printouts of every relevant statute with applicable sections highlighted, my formal demand letter and his response, and a 1-page summary tying each of his deductions to the specific evidence and law that made it impermissible. The judge asked Gerald's attorney to explain the basis for each deduction. It did not go well for them. The carpet deduction was directly contradicted by my move-in photographs, presented right there in the binder. The wear and tear question was resolved in approximately 30 seconds when the judge read the statutory definition out loud. The cleaning fee deduction collapsed when they could not produce a receipt. The administrative fee had no legal basis anyone could articulate. The ruling was in my favor on every point. Gerald was ordered to return the full remaining deposit, plus statutory interest, plus additional damages triggered by the deposit handling violations, plus my $40 filing fee. The total was approximately 3 times what he had originally withheld. Gerald paid within the court-ordered window. I subsequently looked up Gerald's other properties through public records and found a pattern of prior tenant complaints, none of which had resulted in formal consequences. I believe most of those tenants either did not know their rights or did not feel they had the time and energy to enforce them. That is exactly the calculus landlords like Gerald depend on. They count on tenants not knowing the law, not documenting their tenancies, and not having the patience to follow through. I documented, I knew the law, I followed through. What I want anyone reading this to understand is not that courts always deliver justice or that the process is easy. What I want you to understand is that the tools to protect yourself often exist and cost almost nothing to use. Small claims court has low filing fees and requires no attorney. Tenant protection agencies take complaints at no cost. The law in most states has specific enforceable provisions about security deposits that landlords routinely violate because they have learned they can get away with it. That calculation changes the moment a tenant decides to make them prove their case. Know your rights. Document your tenancy from the first day to the last. Keep copies of everything. Send important communications in writing. And understand that when a landlord tells you that you probably will not follow through, as Gerald essentially told me, the most powerful thing you can do is prove them wrong. I did. Every cent came back with interest. There is a follow-up that I think is worth sharing. About 6 weeks after the judgment was paid, I ran into one of Gerald's other former tenants at a neighborhood event. We ended up talking for about an hour. She had rented from him 3 years before I did and had experienced an almost identical situation, similar deductions, similar dismissiveness, similar assumption that she would not follow through. She had not followed through. She accepted the partial return, wrote it off as a loss, and moved on. She told me she had felt defeated about it for years and had always assumed there was nothing she could do. I told her what I had done. I walked her through the statute of limitations on her claim, which had unfortunately expired. But I told her about the Tenant Protection Agency, about the public complaint record, and about the fact that her experience was now part of a documented pattern that could support future tenants who needed to act against him. She filed a complaint the following week. 3 other former tenants have done the same since. After I put together a simple information sheet explaining the process and shared it through a neighborhood group. Gerald is currently the subject of a formal investigation by the State Tenant Protection Agency. I do not know what the outcome will be, and I am not the one driving that process. I simply documented my own experience and made the information available to people who could use it. That is, I think, the appropriate response to someone who has made a practice of exploiting tenants who do not know their rights. You cannot fix the individual cases that have already closed, but you can make it harder for the same person to keep doing the same thing to the next person, and the person after that. I want to be honest about something. None of this is satisfying in the way that revenge stories are supposed to be satisfying. There was no dramatic confrontation, no visible moment of reckoning, no scene where Gerald understood what he had done and felt the full weight of it. What there was paperwork. Carefully organized paperwork, filed correctly with the right agencies at the right times. That is genuinely what worked. I find that almost funny in retrospect. The least cinematic possible form of justice turned out to be the most effective one available. Know your rights, keep your records, and if someone tells you that you will not follow through, understand that the most powerful thing you can do at that exact moment is decide that you will.